To me, this says I don't like them. Just brothers, just talk. Say, sir. I think you are used to them, but to me, they are not. I don't enjoy them. I mean, important thing is a human being, what you can do to help society. That's it. It's not titles and these sort of. We're all human beings. Fine relations, that's the important thing. Okay.
Indeed. Well, you've earned it. But I thank you very much for staying up to join us here on Ghana Tonight. And you saw my colleague run through what the latest is with this matter. You have followed this case right from last week, Tuesday, when the speaker was petitioned. And then after the 48 hours reflection, he gave a reasoned ruling. On Thursday, the NPP caucus, led by the leader, went to the Supreme Court to seek to have the speaker's decision, as was communicated last week, Thursday, in declaring these 4 seats vacant, set aside. I mean, having followed all of this, what's your own view about how events have played out in this case?
Yeah. Well, the speaker did not, he referred to the fact that he had been served with a court order from the Supreme Court. It was one of the factors that he took into account in adjourning matters indefinitely. So the effect of it is that Parliament is not in session, is not operating for some time. I mean, until it reconvenes for active work. That's what it means.
I see. And as we saw today, indeed, he adjourning Parliament indefinitely. Some right from Tuesday and what happened on Friday, some have right from Friday to this moment questioned the Supreme Court's jurisdiction in getting into this matter and the form and nature of this. You know the original jurisdiction of the Supreme Court. Will that concern be one that you would share, that the Supreme Court's jurisdiction was invoked wrongly in this case?
Well, as far as I'm concerned, this vacation of seat matter is specifically dealt with in Article 99. I think you know that, isn't it? 97. No, 99. It deals with vacation of office, among other things.
Yeah.
But 99 is as follows. That's what the article says. The High Court shall have jurisdiction to hear and determine any question whether a person has been validly elected as a member of Parliament or the seat of a member has become vacant, or a person has been validly elected as a Speaker of Parliament, or having been so elected has vacated the office of Speaker. A person aggrieved by the determination of the High Court under this article may appeal to the Court of Appeal. Well, that's another interesting dimension. So the question involved here is one relating to vacation of the seats of the 4 MPs involved. And so it's a matter for the High Court, not for the Supreme Court. Yeah, so to that extent, invoking the Supreme Court over this matter is wrong. They don't have original jurisdiction. You see, original jurisdiction means invoking because at first instance, that's original. But they have referred jurisdiction in the sense that from even this matter, because if a constitutional provision comes up, which is not plain and straightforward, requiring interpretation, Article 130, which gives the interpretative power and the enforcement power to the exclusive to the Supreme Court, says that if a question relating to those issues arises in a court lower than the Supreme Court, the lower court shall stay the proceedings and refer the matter to the Supreme Court for determination, and then shall dispose of the matter before them in accordance with the interpretation. So, once Article 99 has entrusted vacation of this matter to the High Court, the Supreme Court to say you don't just go straight at first instance to invoke it in a matter like this, but it has referred jurisdiction if an issue of interpretation related to the Constitution arises. So to me, that's how I see it.
I see, and the Speaker, in reading his decision on Thursday, was quite clear in indicating that he was not seeking to interpret 97(1)(g) and (h), but was applying that particular article and the details of it if violated. And as you have just made reference to the fact that the details of 97 is clear and is applicable automatically. With what we're dealing with right now, the Supreme Court has been asked to, as it were, come in because Alexander Afenyo-Markin makes the argument that the Speaker sought to interpret the Constitution. And so the Supreme Court then takes a decision that the execution of the Speaker's decision as communicated to declare these seats vacant should be stayed. It should not be executed. That's what's happening right now.
Yeah, but in relation to what did he, I mean, assuming he interpreted, in relation to what did he interpret? A vacancy in Parliament. Vacancy in Parliament matter is given to the High Court under Article 99, as I read to you, not to the Supreme Court. That's why I'm saying that, you see, Article 130 gives original jurisdiction of interpretation and enforcement, original. But where it has given jurisdiction in relation to another particular matter, to a particular court, that court doesn't lose its jurisdiction. What happens is, if an interpretation issue arises, Article 130 clause 2 itself says the lower court shall stay the proceedings and refer the question of interpretation to the Supreme Court for determination. And then they will determine the case in accordance with that interpretation. So in such a situation, the Supreme Court has referral jurisdiction, not original jurisdiction. Referral jurisdiction cannot be the same as original jurisdiction.
And Justice William Atugba, if you could put the camera back on, I think we lost you briefly. But then again, there's been that reaction to, if you can hear me now, the decision by the Supreme Court as communicated on Friday to have the Speaker's decision, the execution of the Speaker's decision stayed. And from your legal lenses, is this one that the Supreme Court can do, as it were? Because that's one of the issues that has come up for discussion now, whether the Supreme Court indeed did right in having or indicating that the Speaker's decision should be stayed from where you sit. Is that right?
Well, I've said on some other platform that strictly in law, I mean, I don't see how they could have ordered stay of execution. Stay of execution relates to execution of court judgments using court processes for enforcing court judgments. That's what execution in relation to court judgment means. So you don't apply this to some non-court situation. It's just not applicable. Nonetheless, over the years, the courts have tried to do substantial justice. It's not like the olden common law days when you had to strictly frame your action or relief. Otherwise, it would be pernicious. Try to do substantial justice. So if somebody comes for a stay of execution and you see that, oh, I mean, it's just nomenclature, but if you had asked for injunction or some other suitable order, we shouldn't throw the person out because of that technical choice. So you look at the substance of the thing. Even they call it stay of execution, but all the intent is suspend the force of your ruling, the effect of it. That is the substance. An injunction can achieve that. So I think that the emotive, clinging to epithets, it's neither here nor there. That's not very helpful at all. Yeah. So then, in substance, I think that's what the court did.
I see. And before I let you go, no, we're going to have an extensive conversation on this matter subsequently, but I just want to find out from you, there are many, because of this particular instance and a few others in the past, that have expressed concern about the workings of the Supreme Court currently. Now, having served at the Apex Court for this long, do these concerns raised have merit? And as you have heard, do they raise any eyebrows for you, or these concerns being expressed about the workings of the Supreme Court is much ado about nothing?
If it raises eyebrows, yes, my eyebrows will be raised. As a common matter of human inclination. But that's not a matter of law for me. I cannot know whether they've done so only in respect of this one or in respect of some other matters. All I can say is that courts do expedite cases which they think of very pressing importance. So these things can happen. However, if, in the terrain of constitutional adjudication, parity of treatment is not given, parity of circumstances, then you can complain. But I have not ceased with the whole gamut of constitutional cases before the Supreme Court and how they have handled them. So it's difficult to say whether this one was exceptionally expedited when others. That's matters of fact. A matter of fact. Maybe you, the journalist, can know. You can go to the Supreme Court and find out a number of actions that have come before them recently, and in terms of their pressing character and how they've treated them. I sit in my house here.